Very good afternoon, dear students. Today I'm going to handle the subject called labor legislation. Since many of you are working already, you'll be knowing and having the experiences of the relationship between workers, employment, employer, and also the government. And might of you know about the laws relating to the employees or the laborers who are working in the organization, right? Who are called as a labor here? We actually say that labor are the workers of the organization. There may be a workers or the employees of the organization can be called as labor. Legislation, in the sense, it is a law relating to the labors. That is, laws framed by the government relating to the workers or the trade unions or the employers of the organization, and also relating to the relationship between employer and employee. Not only the employer and employee, even it is between employer and employees and employees. So these are the laws relating to the workers, employers, employees, or it can be in terms of employment, social security benefits, or even for that matter, it covers all the aspects of workers who are working in the organization. This is called as labor legislation. So, in a simple sense, to say labor legislation is the laws of the law relating to the labors. Okay, look at here the meaning of labor legislation. Labor legislation, it is a body of law. As I said, it is law. Legislation is a statute or the laws, the framework, the set of principles framed by the government to address the problems or the issues, the rights and restrictions of the workers and the organization is called as labor legislation. And this labor laws defines the rights as well as the obligations of the workers and also the union members, the employers in during the working hours and also at the workplace. So this law covers various aspects of the employees who are exploiting from the employees or the laborers who are exploiting from the employer, who are exploiting from the superior workers of the organization. So in order to protect them, this labor legislation or labor laws came into force in different ways by, and it is set up by the government. Let us understand that in detail. Before to that, let us understand about the objectives of labor laws, objectives of labor legislation. Why this labor legislation came into force? What's the reason? What's the purpose of this labor legislation? The main objectives of this labor legislation is to protect the workers. It is to protect the workers from profit seeking exploiters. Who are called as a profit seeking exploiters? Suppose, take an example. I am a worker or an employee working for one organization called ABC. Okay, so in ABC there are workers, superiors, subordinates, and also the employers, right? So here the profit is belongs to whom? Every organization, the owner of the organization or the management of the organization or the board of directors or the shareholders of the organization, they invest some amount of fund into the organization, and in turn, why they invest money? By expecting returns, right? So they expect return in terms of profit. Who are the profit seeking persons or the stakeholders of the organization? They are the owners. They are called them as owners of the organization or the employers of the organization. So just for the purpose of earning a profit, they may exploit the workers. They may exploit the workers just to improve their profit, just to increase their profit of the organization. So this is labor legislation is came into force in order to protect the workers of the organization, in order to protect the workers from exploitation, in order to protect the employees from exploitation. Okay, next is to promote cordial industrial relationship between employers and employment, right? What is employment here? Employment is nothing but job, right? So here, when the employers are work when the employers are given an opportunity, employment opportunities for the employees, along with that they must also have to provide good working environment for an employees to work, so that there will be a good working environment in terms of cleanliness, hygiene, or even they must have to provide the benefits required, benefits needed for the employees in time. It can be a monetary benefit or non-monetary benefits, such that it is possible to maintain a cordial relationship. So this labor legislation makes the employ or protects the employees to get to avail the benefits whatever it is needed by them, whatever it is their rights. So it is possible for them to avail these benefits. Next is to protect the interest of women, to protect the interest of women and children working in the factory. I'm sorry, before to that, to preserve the health, safety, and welfare of the workers. See, for this, when the employee is working in an organization, it is the responsibility of the employers to provide safety measures, and also to concentrate on the healthcare aspects of the employees, and also to protect and to provide the welfare of the employee welfare by the organization. So it is very much necessary, for which we have labor legislation to protect that aspect, and also to protect the interest of women and children working in the factories. So the earlier there was a discrimination in terms of payment of wages, or providing equality, or in terms of rights or promotion. There was a discrimination between men and women, and also they were used to have adopt children, that is a child labor, into the organization by paying very less salary with more work. So when these all the cases, the labor legislation, this labor legislation or the laws relating to the labors protect the employees by providing their benefits, that helping to avail their rights as a in terms of benefits required for them. Next is, it establishes the legal system. So as I said, it is a law. Labor legislation is what? Labor laws, right? So legally, the government impose some restrictions on the employers to maintain a cordial relationship, employment relationship, such that if the organization provide or maintain a good working environment, healthy environment, which sorry, which promotes with productive work. So when they utilize the resources of their organization, including the labor, when they utilize the organization employees in an optimum way with good rewards for them, then definitely they also work hard for the organization. In turn, it leads to more and more productivity, right? Next, in order to correct the imbalance power between workers and the employer. So earlier this was a case where there was very much discrimination and also imbalancing the power between employer and the employee. But nowadays most of the MNCs are giving an opportunity for the employees also. Opportunity for whom? To the employees also. At in what and where they are giving employment, opportunity for the employees in terms of voting at the time of decision taking, and also they are encouraging the employees to become a shareholders of the organization by giving bonus, by issuing bonus shares for them instead of giving a bonus cash bonus. So they, like this, they are also promoting the employees, and to make in the minds of employees to feel that they are also owners of the organization. If they feel that they are the owners of the organization, if they feel they are the owners of the organization, then it is very much necessary, and it is possible for the workers to work for them, for their own organization in a very good manner, right? Next, to prevent the employees from dismissing the workers without good cause. What happens The organization, in any organization for that matter, the employer says to the employees, even they specify in the employment condition, employment agreement also, that whenever the employee wants to leave the job, they have to give a minimum period of notice. In advance information must be given to the employer. It may be a 1 month or 3 months notice period should be given. But to remove, like we can say fire, the organization charge fire on the workers by dismissing them without giving a prior notice, without giving a prior notice for the employees. So this was one of the major problem. So this labor law protects from this, prevents the employees to dismiss the workers without giving a good reason. Next, to promote the workers' empowerment as well as workers' protection. Of course, they must have to empower the workers. The organization must have to create an employees, but through training and development, by creating an awareness to the workers about the laws, regulations, rules, policies in the organization. And also they must have to protect the workers from various aspects in terms of job security, or in terms of healthcare benefits, and also in terms of insurance, or in terms of retirement benefits. Like this, they must have to be protect the employees or the workers by, and also empowering them, which in turn benefits the organization only. Why? Because employees, when the employee feel that it is their own organization, or they, when they feel that they are getting all the benefits what they feel or what they expected, when they are expecting that more than the benefit what they have expected is been received by the from the organization, then they feel very happy about towards the organization. When they feel very happy towards the employers or the employment, like job, or towards the organization, definitely they work hard without wasting their time. They feel that it is their own organization, they are permanent employees, and the management or the owners of the organizations are very liberal for them, so that they can happily work for the organization. So these are all the various labor legislation, because the law came into picture only when there is an exploitation, only when it is not possible to control, when it is not possible to protect the protect the society interest, societal interest, then laws will came into the picture. Next, principles of labor legislation. Principles of labor legislation. See here, there are four principles of labor legislation. One is social justice, social equality, social security, and national economy. These are the four very important principles of labor legislation. This labor legislation came into force with this four principle. First one is social justice. So, social justice, ಸಾಮಾಜಿಕ ನ್ಯಾಯ ಅಂತ ಕರಿತೀವಲ್ವಾ. So here to give equality, justice, social justice to the employees or workers of the organization, the labor laws mentions that employees must also have to be given a voting rights. They must have to be given voting rights. As I said, nowadays most of the MNC companies are issuing ESOP. What is that ESOP means? ESOP is nothing but ESOP, employee stock option plan. What is this employee stock option plan? Employee stock option plan, in the sense where here, at the time of issuing the shares, the organizations are keeping some of the stock to an employee. They are offering an employee also to purchase the shares of an organization. They are giving preference for the employees to purchase shares of the organization, so that the when they purchase shares of the organization, they will get a voting. They will become the owners. When they'll become owners, definitely they'll get voting rights, right? So they will also be part of the organization. So this is called social justice. Next is healthcare. So here, as a part of social justice, the organization must have to concentrate on the healthcare aspects of the employees, so that they have to give a medical benefits provide a medical benefits to the employees and also to the dependents of the employees. And when they are working in the dangerous place, they must have to be provided with all the precautionary measures. And then hunger and food securities. See here, the organization must have to think that the workers or the employers are working for a salary or a daily wages. So when the minimum amount of salary has been given for them, minimum amount of salary or the wages is been given regularly on time for them, it may helpful for them to lead their livelihood, right? Instead of postponing in making the payment, or instead of deducting the loss of time of the employees from the salary, this may affect their livelihood, right? So this hunger and food security, the organization must have to think of it. Or some organization are providing canteen facilities with free of cost or with minimal charge. And also they're also providing various food security benefits to the employees in order to protect them. Next is climate change. Climate change in the sense here, take an example of covid-19. So during covid-19, India completely, not only India, even out other countries also. And even in India also, our honorable Prime Minister was announced lockdown, right? During the lockdown period, two times lockdown period was been announced. During the lockdown period, it was announced by the government to give a salary during the lockdown period, even when there is no work with pay was been announced by the government. So but most of the companies have been followed, but some of the companies have not followed. They have not paid the lockdown benefits, they have not provided the lockdown benefit with salary to the workers. So this was the problem during this kind of climate change. So when there is a inevitable situation, because climate condition or the nature effect we cannot predict it, right? So this with this as a part of social justice, the organization must have to follow the regulations of the organization. Otherwise it will be a problem for them, because the employee feel that the organization is not in favor of the employees. When the organization is not in favor, definitely they may not come forward to work hard for the organization, right? Next, social equality. Social equality here, as a part of equality, equal rights must be given. Equal rights, equal autonomy, equal pay, equal access, equal status must be given, right? So these are all the part of social equality. Take an example here. When the employees, like men and women are working in the organization, when men and women are working in the organization with the same work, same designation, uh, and same hours they're working, if that is the case, same payment must be made, right? There must not be any discrimination in the payment of salary between men and women. Next, and also equal autonomy, equal freedom must be given between the employees, within the employees. When one employee is favored to the management, for them more benefits, more autonomy is given. And the other worker who works really hard for an organization, who works for the organization, but he is not in favor of the management, but he works hard, but for him, when he is not favored, obviously what the management will do, they may not given equal access or autonomy for them, equal status for them. So this kind of discrimination happens between workers and workers, right? So this kind of discrimination between workers and workers, between women and men workers, and also between child and the workers, must have to be removed, eliminated here. They all must have to be given equal rights, equal power, equal pay, equal wages, right? So equal pay, equal access, and also the equal status must be given. Next is social security. What does the social security includes? As a part of social security, see, since most of you are working, when you feel that you have to work for an organization for a longer period, Can you comment in the chat box? When you feel that you have to work for an organization for a longer period, when you want to continue in the same organization, when you want to not quit the organization, share your views in the chat box. You're getting my point, right? Very good. Somebody said that when there is a good working environment, you no, I don't want to continue in the same organization, or you may not be working. So my question is, think that you are working for one organization and you wanted to continue in the same organization without quitting the job. When you feel that you want to do work in that organization only, suppose xyz is a company, you have joined there with some designation for which you are getting good salary. So you want to, you are from past 5 years you are working in that organization, and also you are feeling to continue in the same organization without quitting, or without changing the job. When you feel, yes, when we feel comfortable, when there is a good environment, when my work is recognized, when more facilities given for an employees, when there is a full satisfactory. So when somebody wants to continue in the Infosys, means brand recognition. Next, when we receive recognition for the position, when there is a good salary and peaceful atmosphere, very good, very good. When there is employee satisfaction, very good, definitely correct. When there is a good environment, when the good benefits, what we expecting, what we are working for, and what we are working for which, when we get a good rewards, when we recognize in the organization for our work, when there is a peaceful atmosphere, when there is a equal equality, that is social equality, what we said. So when the employer fulfills the needs of the employees, we feel that we want to continue, right? And also, for how long you continue in that way, when the organization recruits you for a period of only 2 years as a temporary employee. Okay, as a temporary employee you have been recruited. After the completion of 2 years, you don't know whether you will be continued or not. What will happen to you? You are being given an employment agreement to you. This employment agreement, in that employment agreement they mentioned that uh, you have been recruiting for a period of 2 years as a temporary, either during the campus selection, or when you are applied for a job, you are being given an employment agreement by the organization and specified that you are been appointed only for a period of 2 years. What will be your next condition? You need maximum years, right? Okay, in the sense, we expect the safety for our job. When we don't know, you are an employee today, but you don't know whether you will be employee for the organization tomorrow also. Because many organization, when they feel this employee is not required, they may remove as and when, without giving a notice, without giving a reason also, right? So this is the case happening during COVID period. Because there was no contract, no project, no work in the organization, most of the, or few, or most of the organizations were removed employees, were dismissed or removed the employees or the workers in the organization due to no job. So the employees will be continuing there in the organization with a fear of when the organization may remove them from the job, right? With that fear, is it possible to work for a longer period? For which, what we need a job security, means regularizing our job, making a permanent from the temporary, regularizing our job. When we give a job security, is giving that you are a permanent employee of the organization. When we feel that we are the permanent employees of the organization, there is no like temporary, we are permanent employees of the organization. What happens when we feel we are the permanent employees of the organization? Definitely there will be no job fear, There will be a complete job security, so that it leads to eliminating from your mind. It leads to the job fear will go out of your mind, right? So that you can work, or the employees can work happily. Along with this job security, even the organization must have to provide various benefits required for them. What kind of benefit? It can be in terms of monetary benefit or non-monetary benefits, right? So monetary benefits can be a salary, wages, bonus, compensation, incentives, increment, right? All these are the various monetary benefits must have to be given. And non-monetary benefits like retirement benefits, like after when the employee worked for 5 years, more than, if he is even working for more than 5 years also, then he must be given a gratuity for working more than 5 years. DNS allowance, okay, is a monetary benefit. Okay. Next, perquisite, any kind of perquisites, or leave encashment allowance, leave encashment allowances. So these kind of various retirement benefits, pension settlement. So this kind of retirement benefits fits must have to be given. The non-monetary benefits, like the non-monetary benefits, this non-monetary benefits of the organization, which includes perquisites, what I said, the perquisites, the medical benefits, the education facilities, not only to the employees, even to the dependents of the employees, if they have given education facilities, or insurance, or any medical benefits. So if all these are given to the employees, the employees think that they have a secured feeling towards organization. Next, national economy. It is also one of the important point, where this national economy, as a part of national economy, the organization, I mean the government must have to take care this. But at the time of announcing the budget, they must have to provide special package for the laborers, and also some amount of funds must be kept for the employees who wish to continue their higher education through this scholarship. And also the organization or the government must have to create awareness programs about the laws relating to the labors. So these kind of awareness programs must have to be conducted by the government or even the organization, such that they will also know, they may protect from the exploitation from all these kind of activities, right? Okay, now let us move into the next one. Classifications of labor legislations in India. See, this labor legislations are classified into mainly six heads, under six heads. First one is regulative laws, wage related laws, protective laws, um, or welfare laws, the laws related to the social security. Like this, there are various laws relating to the labors, particularly to the labors, are available here in India. Let us discuss one by one about individual these laws, mainly classified this into six categories. First one is regulative laws. These are the laws related to the regulations of industrial relations. Regulative laws, in the sense, the laws are the legislation which was established mainly for the purpose of regulating the relationship between employer and employees, relationship between employer and employees, and also to maintain good setting up of industrial disputes, or the rights and obligations of the employers and the workers. 1 minute. So, in order to protect the employees from the exploitation, and to regulate the relationship between employer and employee, employees and employee, and to have a good cordial mutual relationship between them, this regulative laws was established. These regulative laws includes, first one, Trade Union Act 1926. Next is Industrial Disputes Act of 1947. Let us discuss that one by one in detail later. I'm just giving the name of it now. So under the regulative laws, we have Trade Union Act and Industrial Disputes Act. Next is wage related laws. The wage related laws, in the sense, the name itself specifically said that the law which governs the wages, right? The laws which governs the wages, to fix the minimum wage, to provide the bonus to the employees, and to fix the equal remuneration to the employees. So all these are the laws relating to the wages, wage earners, so which includes Minimum Wages Act 1948, Payment of Bonus Act 1965, the Equal Remuneration Act of 1976. These are the laws relating to the wage earners. Next is next is Trade Union Act. Sorry, one second. Okay, so the next type of labor legislation is protective laws. What is this protective laws relating to? Mainly, this protective law is relating to the working hours, the condition of service and employment, and it was mainly established with the objective of fixing the minimum labor standards and to improve the working conditions. So this is established with the main objective of fixing the working standards for the employees or the workers, and to protect them from labor legislation through this labor legislation. So this legislation, which is laying down the minimum labor standards in the areas of work, the safety, employment of children and women, and also the manners of payment of wage comes under this category. Okay, so I have taken only minimum with very less laws relating to this here. One is Factory Act of 1948, and the second one is the Mines Act of 1952. Next is and the Plantation Labor Act of 1951. So next law is welfare law, and this welfare law is relating to the deprived and disadvantaged group of the society. So the disadvantaged group of the society, like minority group, or the child welfare, the women employees who are deprived from getting or availing benefits from the organization, from the society. For them, in order to protect from the welfare activities to the employees, this welfare law was established, and this mainly includes the child labor law, that is Child Labor Prohibition and Regulation Act of 1956. We know the child labor, in the sense, the here the organization, when there is a the worker, in the sense the children who are under the age of 15, who are under the age of 15, working all kind of works, and also in terms of dangerous work, the children who are under the age of 18, who are being employed in the organization, is illegal. As per the Child Labor Act, as per the Child Labor Prohibition and Regulation Act, the worker, the child worker who are below the age of 15, doing all kind of work, and if there is a dangerous work below the age of 18, is also illegal. It is specified as per the Child Labor Prohibition and Regulation Act. And I wanted to specify the statistics here, like child labor. There is a highest child labor in India, having 5.8 million child labor who are working in the organization between the age of 5 to 17 years. India is a country, it is the first country having highest child labor, followed by Bangladesh, Pakistan, and also Nepal. So but India is the first country having highest child labor here. Next is on Okay. Laws relating to the social security. As we discussed about social security, in order to protect from the contingencies, the future contingencies, suppose in case any death happens of the employees, what will be next for his family members, who will take care of his family members? So for them, the employer, either in terms of monetary benefits or giving job for the dependents of the employees, like this alternative arrangement must have to be made by the organization, right? So like this, the social security legislations which protects the employees from providing the social security benefits. Let us understand what are these, what does this includes. First one, Employers Compensation Act of 1923, Employers State Insurance Act of 1948, Employers Provident Fund and Miscellaneous Provision Act of 1952, then Maternity Benefit Act of 1961. These are the individual acts. We'll discuss in detail of all these laws relating to the five heads, that is protective laws, regulative laws, welfare laws, wage laws, and also social security laws. So all these in detail, let us discuss one by one later. Okay, this is the first law. This is a regulative law, right? You can see here, Trade Union Act of 1926. Here, this Trade Union Act of 1926 is a regulative law, and this was established in the year 1926. So with what intention this trade union was established, and what is this trade union means? I'll just give one example for you. In the recent the workers who works in the bank, they have called for a strike, you might be knowing. During March 28th and 29th, 2 days, there were the employees of banks have been gone for strikes. Why they were gone for strikes? In order to protect them from government's moves to with relates to privatization of public sector banks, and also the banking law amendment bill, what the government is willing to establish that bill 2021. So with that, to oppose that, the bank employees were went to a strike. Can you tell me whether the bank employee individually taken this decision? Individual bank employees have taken this decision, and they made a group of it and went for strike? Definitely not, right? It is not possible for the individual employee, because there will no, yes, definitely there will be no rights for them, no autonomy, no attentive for them, that to go for a strike individually. There must be some registered association. So that registered association, who are registered as per the legislation, can go for strike. So that association, registered association, is called as what? Trade union. So it is a set of, or the group of employees. Union means what? The group of employees, group of people called as union. Trade union means what? Trade union is a group of employees of the organization, and this was established mainly with the intention of protecting the exploitation from the employers and to avail the benefits. What happens when the individual workers, we say that when there is an individual, we unit when there is a unity, we can avail all the benefits, but when we go individually, we cannot able to get our benefits, even our rights also, right? So it is very much necessary for the organization, I'm sorry, employees, to have a trade union. Even it is required for smooth running of the business also, and for availing the benefits from the organization in a smoother manner, this trade union helps. So this trade union is a combination, whether temporary or the permanent. It can be a temporary employee or the permanent employee. The combination of the employees is called as trade union. This was established for regulating the relationships not only between workers and employers, but it is also between workers and workers, and also between employers and employers. And this Trade Union Act of 1926, established by the government, is extends to whole India and applies to all kind of union of the workers. It is not only to the particular sector. It is not only to the particular industry, it is not only to the particular organization, not only to the particular type of workers or the employers. It applies to all kind of workers, all kind of association of employers, all kind of, for all kind of activities this can be established. And this trade union must have to be registered to have the power for them, and which aims at regularizing the labor management relations. Okay, so the regularizing the labor management relations, definitely in order to continue with the same, with good relation, mutual relationship between employer and employee, this trade union is very much necessary. Let us understand this objectives of trade union. Here, this objectives of trade union, which includes security for workers, continued employment, prevent retrenchment. Like there are various objectives of trade union. Let us discuss one by one. Security for workers. As I said, it can be a job security, it can be a social security benefit, it can be a retirement benefits, or regularizing the employees from the organization for any kind of security, for that matter, when the employer is, sorry, employees or the workers are working in the dangerous place, they must have to be protected, they must have to be given good care, preventive measures, precautionary measures must have to be taken by the organization. And for an employees, for protecting the employee, and to improve the standard of living of the employees, and to provide a good security for an employees, insurance must have to be taken care by the organization, medical benefits, provident fund, these kind of workers compensation benefits must have to be given by the organization. These are the security for the workers, security benefits to the workers must have to be provided. If not provided, definitely there is a trade union which protects the employees from availing these kind of benefits. Next, continued employment. As I said, as I discussed, this is very much necessary. When the employee feel that we don't know when the organization is going to remove us, when there is a fear, the fear of loss of job in their mind, they cannot able to work happily, right? So it leads to clashes in the organization, it leads to more and more mistakes. So all these are the problems happen. So continued employment, in order to regularize the employees, or to continue the employees in the organization for a longer period, this trade union protects them. Next, prevent retrenchment. What is meant retrenchment? Retrenchment in the sense removing the employees by giving notice, proper notice and benefits. Sometimes what happens, they may not give benefit also. So purposefully think the organization, like in terms of either a VRS or the retrenchment. If they are the permanent employee, they ask the employee to go for VRS compulsorily. If the organization, if the employee is by himself voluntarily going for retirement, that is okay. But when the organization themselves is removing employees from the organization, that is called as retrenchment. So this is very dangerous for for the employees and also for the organization. Why? Because it leads to the name, the good fame name of the organization will be affected negatively in the market, right? When they take this kind of action against the employees. Next, layoff and lockouts. Lockout means the organization temporarily closing down of the business is called as, closing down of the entire business is called as what? Lockout. It is not completely closing. It is a temporary closing. Temporary closing of the organization due to some reason is called as what? Lockout. Then what is layoff here? Layoff in the sense removing the employees. Layoff means MNC company, majorly the MNC company, what they give pink slip to the employees. By giving pink slip, they may not give any prior notice for them. They just say, by giving pink slip for them, tomorrow onwards you don't require for the organization, you don't come to job. So this is called layoff, removing the employees without giving notice. That is called as layoff. So this trade union protects the employees from this lockout and layoffs, because the organization must have to give a notice, the information to the trade union before prior in advance. They have to inform to the government also relating to this lockout or the layoff, not the layoff. They must have to given the information to the government also to take, they have to take a permission from the government. And them if the trade, if there is a trade union, definitely they protect. They may go for strike. They may put a case in the court also, which such that the employment in the organization may be protected. Next is collective bargaining. As I said, when we go individually, we may not able to avail the benefit. When we go collectively, the trade union helps for availing the benefits, availing the benefits of their members collectively. So this helps the employers and also the employees to gain the benefits collectively. When the benefit is needed for an employees collectively, it is applicable to all kind of employees. Through this trade union, it is possible to avail the benefits, to get the benefit from the organization, for not only for a particular employee, to all the members of the trade union, it is possible to get those benefits from the employer. Next, protection and privileges. Yes, protection from various kinds, as we discussed from that past. Next, privileges. Privileges can be in terms of giving priority to the employees, recognizing their job in the organization, as you are also specified here, recognizing the job in the organization for the work of an employee. And also when there is a promotion, not demotion, when they are promoted to the a higher level, when they are promoted to the higher level with good salary, good incentives, and also with equal autonomy, when equal privileges are given to all the employees who are working in the same level of employment, then definitely the employees will feel happy. So this trade union will help for availing this kind of privileges from the organization. Next, regularizing labor management relations. As I said, the labor and the management, there are three we specify that there are three different categories of employees who work in the organization. We can say the top level employee, middle level employee, and the lower level employee, and we write that in the triangle shape. Top level will be in the peak, that is in the top most position, and next comes under the middle level employees, and at the end top level employees. Why it is in the triangle shape? Because the top level employees always will be less compared to the middle level, and middle level will also employees will also be less compared to the lower level employees, right? So here the top level employees will be either management, board of directors, or the any CEOs of the organization. But middle level employees can be a supervisor at the supervisory level or the managerial level, whereas the lower level employees are the operational level employees. So there will be more number of employees. All the directions from the top level to the lower level employees will be directed through this middle level employees. So there must be a good cordial relationship or the mutual relationship between top level to lower level, and also with the middle level is very much necessary. So this trade union helps for the maintaining or protecting their relationship between labor and the management. Next, this trade union, for trade union, in order to have a formal trade union, the trade union, the members of the trade union must go for registration. So what are the formalities to be fulfilled to get a registration of this trade union? Here there are some documents required for registering the trade union of a particular organization. They have to provide the filled with the details in a prescribed form. What details they have to specify? The names, occupation, and address of the members' place of work, where they are working, in which place they are working, what is the registered office, the address of the registered office, the name, age, address, and occupation of the office bearers. That is the top position in the trade union must have to be mentioned in the registration form, in the prescribed form provided by the government. Okay, so these are the required document must have to be provided for registering the trade union, and also very much necessary to have a minimum number of members to be registered. How many members should be there then? At least minimum of 7. Minimum in the sense more than 7 is also okay, but minimum of 7 members must be there to get a registration. 7 or more members of the trade union may, by subscribing their name as a office bearers or as a members of the trade union, it should be specified at the time of registration how many members are there for the trade union. For at the time of registration must have to be specified, and what are the compliances they are fulfilling for registration, what the rules and procedures they are following for fulfilling the registration. Everything must be known by the members who are present at the time of registration. And it says that there must be at least 10%. 10% of the employees or 100 of the workmen, whichever is less, engaged or employed in the establishment. It is possible to go for a trade union only when there is a minimum of 100 workers, or 10% of the workers, whichever is less. At least minimum of 100 workers or more than 100 workers can be there for taking registration for the trade union. If the application filled in the prescribed format, produced for the purpose of registration, when there is no minimum requirement is fulfilled, then it leads to a cancellation. It leads to a cancellation. The government may cancel the registration if they found that the information provided is fault, is fraud, there is a mistake. So then they may cease to cancel the registration. So when there is no minimum number of members also, the registrar of the registration of the trade union may cancel the registration. And after registration, they must have to file a return every year, as how the company files the return with the audited report, how they prepare the financial statement having balance sheet, trading and profit and loss account. So with like in the same manner, even this trade union must also have to prepare the general statements with the audited report in the prescribed format, having not like balance sheet like trading and profit and loss account, because it is not the profit oriented business here. This is a, since it is like a non-government non-profit organization, it has to prepare receipts and expenditure statement in the prescribed format, and it must be produced to the registrar of the companies before or on or before 31st December every year. After the registration, it should have to fulfill this. And when there is a necessary to change the name of the trade union or the registered office of the trade union, they have to give a note information, and to get the consent from the consent from the members of the trade union by conducting a meeting. At least two-thirds of the members must vote for this change of name and registered office, so that it is this proceedings of this meeting must have to be enclosed along with the change of name, the prescribed form for the change of name of the registered office, and should be sent for changing of this. In case if they found faulty in fulfilling the compliances after the registration of trade union, the government impose penalties for the offenses, and or penalties or the punishment they impose on the trade union. So under section 31, under section 31, for making false to enter in or any omission in general statements requiring for sending the returns, What happens, as it is specifically said, every year the trade union within 31st December of every year they must have to prepare a general statement having receipts and expenditure. What are all the receipts came into, like receipts can be the membership fees of the trade union, and expenditure whatever the expenditure they incurred in the trade union for conducting the meeting or for other activities, that must have to be prepared in the general statement, and it has to be filed a written along with the audited report. If they failed, or if they mention any false information, and if it is found that there is a false information produced in the general statement, then they impose punishment or fine up to 500 rupees. If the same is continued, then the additional fault of rupees 5 for each week, not exceeding rupees 50, will be imposed. And for making false entry in the form, but there is a general state, there is no problem with the general statement. But at the time of sending a form, in the prescribed form, if they mention any false information, then the fine will be imposed up to 500 rupees. Then under section 32, in case of supplying false information regarding trade union, if the members of the trade union is passing the false information, wrong information, if they are misinterpreting or misexposing the information of the trade union, then the fine will be imposed up to rupees 200. So these are the penalties will be imposed by the registrar or the government as per the legislation. As I said, the bank workers went for strikes along with by they went for strike on March 28th and 29th by taking prior permission from the concerned bodies. So they have not only the bank employees, they have not only gone with the bank employee, only with the bank employee association, only with that trade union. Instead, rather, they also sent the information, or they also expected by sending information to the central trade unions also to support them. So we have various central trade unions working at very good manner. So these are the various central trade unions existed in India. Like first one, Indian National Trade Union Congress. It is the first and foremost trade union. First trade union existed, and it is dominant trade union. And the second one is All India Trade Union Congress is the second central trade union. And Hind Mazdoor Sabha, this is the third largest trade union of our country. Like this, there are various center of Indian trade unions, All India United Trade Union Center, Trade Union Coordination Center, Self-Employed Women's Association to protect the women exploitation in the society, All India Central Council's Trade Union, Labor Progressive Federation, Union Trade Union Congress. Like this, there are various trade unions existed. If any trade union wants or seeks their support, definitely they present the trade union, all the majority of the trade union will present and also support the support for any causes, for any kind of good causes they will support, and they will also protest along with the other trade unions. Like this, there are various even government trade unions also existed. So with this kind of trade unions, it is possible for the employees or the laborers to protect their rights, protect their employment rights. They can avail the benefits of the employees. Now okay, in the next class, let me continue with the Industrial Disputes Act of 1948. This Industrial Disputes Act of 1948 is the act established to protect the disputes of the employers or the employees, and also with the government. So that will be continued in the next class. Now I will conclude. If you have any doubt, you can write your doubts in the chat box. Yes, I'll share the PPT in the Telegram group. The PPT of today's class will be shared. Is there any doubt? If not, I'll conclude. Okay, right. Thank you very much. We'll meet in the next class tomorrow by 12 o'clock for FM Financial Management class. Okay, thank you.